Hello, students. So, today we are going to discuss the first defense under the law of torts. The first one is voluntary non fit injury. So, voluntary non fit injury is a maxim, and in a case where a plaintiff is voluntarily suffering for some kind of a harm. So, basically, in this, the plaintiff has given the consent for the suffering of such harm. So, he has no remedy for that under the law of tort, and he will not be allowed to complain about the same. So, the reason behind this defense is that no one can enforce a right that he has voluntarily abandoned or waived. So the consent to suffer harm can be expressed or implied. Some of the examples for this defense are first, when you yourself call somebody to your house, you cannot sue your guest for trespass. So, next is if you have agreed to a surgical operation, then you cannot sue the surgeon for it. The next is if you agree to the publication of something you were aware of, then you cannot sue him for defamation. If a player in the games is deemed to be ready to suffer any harm in the course of the game, then he cannot sue if he suffers any kind of harm. A spectator who is gone to watch a cricket match will not be allowed to claim compensation for any damages suffered. For example, if he's hit by the ball, so that means you had the knowledge and you gave the consent for such kind of a harm that might occur. So for the defense to be available, the act should not go beyond the limit of what has been consented. Very important that the consent that is taken place is free. So for this defense to be available, the consent of the plaintiff should be freely given. If the consent is obtained under any compulsion or if it is obtained by fraud, then it is not a good defense and cannot be um, good effective enough. So the consent must be given for an act done by the defendant. So first it should be free, and also it should be given for acts that are done for by the defendant. For example, if you invite someone to your house for dinner and he enters your bedroom without permission, then he will be liable for the trespass. In the case of Lakshmi Rajan versus Malar Hospital, a 40-year-old married woman noticed a lump in her breast, but this pain does not affect her uterus. After the operation, she saw that her uterus has been removed without any justification. So the hospital authorities were liable for this act, and the patient's consent was taken for the operation, not for removing his her uterus. So if a person is not in condition to give consent, then his or her guardian can give the consent. Is guardian consent, it will be sufficient also. Then the consent, if the consent is obtained by fraud, so if the consent is obtained by fraud, then it is not a real consent and it does not serve as a good defense. There are certain cases that you can go through, like the R versus Williams, R versus Clarence, Harthy versus Shine. Now, if the consent is obtained under compulsion, so there is no consent when someone consents to an act without free will or under some kind of compulsion. It is also applicable in the cases where the person giving consent does not have the full freedom to decide. So, this situation generally arises in a master servant relationship where the servant is compelled to do everything that is his master asks him to do. Thus, there is no applicability of this maxim, voluntary non fit injury, when a servant is compelled to do some work without his own will. But if he himself does something without any compulsion, then he can be met with this defense of consent. Mere knowledge does not imply assent. For the applicability of this maxim, the following essentials need to be present. First, the plaintiff knew about the presence of risk. Second, he had knowledge about the same and knowingly agreed to suffer harm. Now, negligence of the defendant. In order to avail this defense, it is necessary that the defendant should not be negligent. If, in case, the plaintiff consents to some kind of a risk, then it is presumed that the defendant will not be liable. For example, when someone consents to a surgical operation and the same becomes unsuccessful, then the plaintiff has no right to file a suit. But if the same becomes unsuccessful due to the surgeon's negligence, then in such cases he will be entitled to claim compensation. That's all. Thank you.